Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, how far can you go? U.S. merger enforcement under Section 2. Recently, there's been an uptick in merger enforcement, and by recently, I mean over the last few years. We've seen more litigation in court and different theories underlying that litigation. Today, we're going to talk about what are the limits of a challenge to a merger that says it violates the unilateral section, the anti-monopoly section of the Sherman Act. My co-host today is Anora Wang. Hi, Anora.
Hi, John.
Nora, what are we doing today?
We're going to talk about a very dynamic area in merger enforcement in the United States, which is can you bring lawsuits or actions by agencies to stop or even challenge consummated mergers under Section 2 of the Sherman Act, which is slightly different than what has been done, which would be under what we call Section 7 of Clayton Act area. So this is very dynamic, and a lot of high-stake cases are involved. So that's what we're talking about.
Who's our guest today?
Our guest today, Koren Wong-Ervin, who was, I hope to mention first, who actually taught me in law school. She is now a partner at Axinn, Veltrop, and Harkrider LLP with more than a decade and a half of antitrust experience, having represented defendants and plaintiffs in high-stake litigations and represented technology companies in domestic and foreign investigations. Koren previously served as the Federal Trade Commission's counsel for intellectual property and international affairs, and as attorney advisor to Commissioner Joshua Wright. Koren is a recognized thought leader and has testified before Congress on domestic and international antitrust issues. She has also served in numerous leadership roles in the ABA's antitrust section, including her current role as the co-chair of the Competition, Consumer Protection Policy, and U.S. Comments Task Force. So many roles important involving U.S. and international antitrust issues.
Well, let's bring her in. Welcome to the program.
Thank you. It's so nice to be here.
Koren, it's very nice to have you. And as we discussed, that this is a very dynamic area, and I hope to get it started, but perhaps giving a little primer to our audience. Let's talk about how usually mergers, including those that has been closed and consummated, how are they usually challenged or policed in the U.S.?
Well, historically, the agencies have brought cases under, as you mentioned, Section 7 of the Clayton Act. But recently, the FTC in particular has started to bring mergers under Section 2 of the Sherman Act, which, as John mentioned, is a monopolization, generally what we think of as unilateral conduct. So, the FTC has said, and DOJ, former Chief Economist Jeff Wilder, that there's some challenges to bringing challenges of consummated mergers that have already closed under Section 7. And so let's try Section 2. It might help us. We might be able to do things like challenge a series of acquisitions together, and we might have a different standard.
Yeah, that's very interesting. So if I'm in a government, I'm not, if I am, and I'm trying to enforce all the competition laws that I'm under my legal authority to enforce, it would be natural or reasonable, to consider everything in my toolbox. And what are the main issues, or what's the difference if I pick this over another, say Section 2 versus Section 7?
Sure. So the FTC recently, in December of 2020, brought a case against Facebook, and they're seeking to challenge long ago consummated mergers, Instagram, which was consummated about 8 years ago, and WhatsApp, which was about 7 years ago. And they brought this in the DC circuit, I'm sorry, the DC District Court, because my understanding is they'd like what they would call a clarification, I would call an expansion of Section 2 law under the famous landmark decision of US versus Microsoft. So we can go into it. There's some standards that they are arguing for that I think depart from how traditional Section 2 has traditionally been interpreted.
Before our audience get further lost, what is U.S. Microsoft case? What does that case have to do anything with merger enforcement? To my knowledge, that was not a merger case.
Sure. So Microsoft set forth a three-part burden shifting. They said, first, the government has the burden, or plaintiffs, of proving that there was exclusionary conduct, and that it had the requisite anti-competitive effects. Then if they show that, then the burden shifts to the parties to show that there were pro-competitive benefits or efficiencies, and then the burden shifts back to the government to show that the harm outweighed the benefits. And so what the FTC has said is that under Microsoft, you don't actually need to prove effects. Even though the court said the plaintiff bears the burden of showing the requisite effects, the FTC has said, no, instead, what you can do is show some kind of conduct that we would reasonably expect to harm rivals and exclude competition, cause foreclosure, and then maybe result in higher prices or reduced output. And Judge Douglas Ginsburg and I have an article from 2020 in which we push back on this. And Judge Ginsburg was the author of the Microsoft decision. So he explains, no, when the court said you need to prove effects, we meant that. And in fact, the court spent fully 20 pages going through what the effects were of Microsoft's conduct. So, of course, this brings us to the issue of, well, what do we mean by effects, right?
Right.
What is effects? And so Judge Ginsburg and I say that effects are, especially when you're looking at backward-looking conduct or a long ago consummated merger, that we should look at what actually happened in the marketplace in terms of things like, did prices go up? Did output increase? Did innovation, was that harmed? And that should be the focus, because in antitrust, as we all know, when prices go down or output increases or innovation increases, that suggests a pro-competitive outcome. That's good. That's normally what we want from competition, or always what we want. Go ahead.
Yeah, I think I just want to jump in as if I'm thinking as someone who doesn't know antitrust at all, and I'm just thinking the government is trying to challenge a consummated merger, and the common sense would be it's already consummated. The effects is already evidenced in the market, isn't that right? Why would that be a harder case for the government to enforce it as it usually would, and then need to reach for new tools?
Well, so we're skipping ahead a little bit to the causation standard. Just coming back a little bit to the effects, what the government is saying is that in Microsoft, the court says you focus on effects, but they didn't actually do that. They actually focused more on harm to rivals. And so Judge Ginsburg and I point out that what the court did was find that there was foreclosure effects sufficient to deprive rivals of a critical mass of users, right? And so this is akin to depriving rivals of a minimum efficient scale, which is the very economics of foreclosure and how we would expect exclusionary conduct to harm competition. And so the inference flowed not from harm to rivals, but from the economics of foreclosure. Now, your question goes more to causation, right? And there is a question. So you're asking, well, we know what happened in the marketplace, right? Like with Facebook, there's evidence that there was exponential output growth following its acquisitions. So we would say that seems good, right? But I guess the question is more, well, could the world be even better without? Mm-hmm. Could prices be even lower? Could there be more privacy? Could it look even better? And that's typically an argument that plaintiffs will make, that, okay, fine, things are good now, but they could have been even better if we had these independent competitors that you had not have bought and combined into one company.
So to summarize a little bit, so there are several key aspects that's different in terms of standard or what's required from the plaintiff, which is the government here in cases challenged by the government. What do they need to prove in a case challenged, such a merger or consummator or not? So proof of monopolization, proof of anti-competitive effects, and causation, which we discussed. Which do you think, if you have to pick among the three, what would be the key, the even more critical aspect that's comparing the standard of the two?
Well, monopolization is key, right? I mean, that's a higher bar, as Bruce Hoffman, the former director of the FTC's Bureau of Competition, said in his speech that sort of started this whole debate. In Section 7, you don't have to prove there's an actual or dangerous probability of monopoly. So that's definitely a higher bar. I would say that the actual anti-competitive effects that you actually should look at price and output. The government would say you don't. The government would also like a lax causation standard. So sort of de facto causation standard is what we call but for. So but for the monopolist conduct, there would have been a different result. But the government would like to use the reasonably capable of, which obviously is lesser, right? Reasonably capable is more speculative. The other important difference between Section 7 and Section 2 is efficiencies. So in Section 2 cases, when a company comes forward and says, I have a legitimate business justification. I did this to protect my brand, to eliminate free riding, to do something that was legitimate, or there were efficiencies. There were reduced costs that we could pass on to consumers. In Section 2 cases, when the court credits those benefits, the defendant almost always wins. You just go home. In contrast, in Section 7 merger cases, courts and the government rarely credit efficiencies.
So that's obviously another reason that might affect how one chooses which law to apply and what sets of precedents that's not going to come with that particular law. But the thing is that there are good arguments to be made on both sides to apply or not apply Section 2 in a merger challenge. But how do we know? If I'm trying to be an originalist, if I'm trying to be a textualist, how do I know, given the statute itself or the relevant legislative history coming with it, should I be applying Section 2 to challenge mergers?
Well, like you said in the beginning, I mean, it's all part of the FTC and DOJ and private plaintiffs' toolkit. So there's not a should. If you're asking which is a higher or lower bar, there is some legislative history. There's the Supreme Court's case in Brown Shoe, which says that the Clayton Act, which was enacted after the Sherman Act, is meant to be a lesser burden. That they quote from the Senate report to the original bill, sort of what we call legislative history. And they say that Section 7 was meant to catch things in its incipiency, right? Whereas Section 2, it was more after the fact and you need effects. So, in merger review in the non-consummated context, it's very speculative. We don't know what happened because the merger hasn't happened yet, right? There is no price output effects to look at. And so I think that's a main difference. Another main difference with Section 2 is what DOJ has suggested, that we might be able to use them to go after a series of acquisitions. So the idea is, the allegation is that Facebook has...
So briefly, what is a series, like what we call serial, serial, well, nothing comes good after that. What is serial acquisition? So what does that mean? Does it mean smaller acquisition come in a sequency, but none of that is challengeable under the relevant statute?
So, people say companies like Facebook have many, many acquisitions. So that would be a serial acquisition. Many acquisitions in a row. And the idea is that you might be able to, it's like a monopoly broth theory. It's the idea that a series of acquisitions, a number of separate transactions each of which alone may not have been anti-competitive, together can be combined to create liability. So I like to call this the 0 plus 0 equals 1. Now, there is some court precedent for this. There's a Ninth Circuit case that did say when you're looking at acquisitions, you could look at what they call the synergistic effect. But there's other courts like the Fifth and the Second and the Federal Circuit that have said, no, when you have conduct-specific tests for things, there's actual defined tests in the law, you're going to analyze them under those. We're not going to do 0 plus 0 equals 1.
The monopoly broth theory, I think that's more if people who are watching the chip industry a little closer, they would be more familiar with that. Again, that's in the conduct space, not so much in the merger space. Is that right?
No, monopoly broth has been applied to conduct and mergers. It's just the idea that a monopolist or a alleged monopolist has done a number of things, that they maybe tied or bundled, offered things together, and they acquired companies, and they refused to deal with rivals. So it's just the idea that you did more than one alleged bad thing.
Right. So what is the problem with trying to analyze a particular or challenge a particular conduct in combination with other things that's I guess in the broth?
So the problem is that, again, comes back to the 0 plus 0 equals 1. Antitrust case law has developed specific tests for different kinds of conduct. So there are specific elements. And so if you don't meet the specific elements for each of the conduct, to then say, well, but we don't like it that you did all these things and companies were going out of business or were not as competitive. So it's a broth. We're just going to put it in all together, and somehow, we're sure that somehow to get all together, there's a problem here. Now, it's different if you say there's a series of like exclusive dealing arrangements, none of one, and you combine the foreclosure effects, right? So it's not that you can't kind of combine the harm, but it's that if you have absolutely no liability, this transaction was good. I mean, it's really important to remember that in the FTC Facebook case, the FTC itself cleared these transactions years ago. And now they're coming back and saying they were unlawful, even though they cleared them. And of course, they say there's subsequent evidence, but that's an important point.
So to have a fair sense of the arguments being made for and against the use of Section 2 to enforce against potentially anti-monopoly mergers, one would think if this is too close, that is too close. But if you put these conduct or a series of acquisitions together, seen in the totality, there might be a competition problem. So I think that's the main argument I have seen. Are there any other good arguments that, Koren, you have seen being played out that's advocating for the use of Section 2?
Yes, so the DOJ former chief economist has a speech where he talks about tipping. Right, he says that each individual acquisition alone may not have met the standards under the law to be unlawful, but at some point they can tip the market in the company's favor, right? And that especially in markets like platforms where you have network effects, so let's say Facebook, where the more users begets more users, the more content, the more advertisers. There's some indirect and direct network effects that it could tip the market, right? And so, to be clear, I don't have any problem with using Section 2. I think that the government should use whatever tool is, they have authority to use. My problem is saying that it doesn't require actual anti-competitive effects, that instead we can just look to conduct that's the type of conduct we would expect to cause harm and then infer harm. For me, when you have long ago consummated mergers, I want us to actually look back and see what happened in the marketplace.
So I understand the DOJ argument. Is what they're saying essentially 0.25 plus 0.25 plus 0.25 plus 0.25 equals 1, not 0 plus 0 equals 1?
So I think that works in the exclusive dealing context where you have a series of exclusive deals that together result in substantial foreclosure. I don't think that works in the acquisitions, because if you found that an acquisition is lawful, it's not illegal, that's zero, right? You don't find that acquisitions are 0.25 illegal. And
Well, but
here the thing is that, good.
couldn't you find that the acquisition had some anti-competitive effects, but that other factors made the merger overall pro-competitive? And then when you start aggregating the anti-competitive effects, they grow, maybe even become exponential, and that's how they get over one.
I mean, the thing is about the Fifth and the Second and the Federal Circuit cases is they said, we have these conduct-specific tests for a reason, and once you analyze it under that, then it's zero. And the thing is, the government's not without power to do what Jeff Wilder wanted. They can challenge the last merger in a series that tipped the market.
I understand that there is an argument being made that if you do have these zero, like 0.5 plus 0.5 plus 0.5, somehow my equation is using bigger numbers than
you got to 1.5, but that's okay. Keep going.
Anyhow, the point is that there might be some uncertainty about enforcement, right? You're going back retroactively and then say that was a merger that we didn't challenge then, but now combined with what we're seeing now, it's somehow problematic. So that's one argument that I've heard being made. Is that something that you would agree to, Koren?
No, I have no problem if market facts change with going after. I mean, I do think there's an unscrambling of the eggs problem, right? It's very difficult for mergers to be unwound. And prior to last week, February 2021, no court since 1957 has approved unwinding a merger that was consummated more than 4 years ago. Now, last week, there was a case called Geldwen, which was the very first case in U.S. history that a court approved unwinding a merger in a private case, so brought by a private plaintiff. And this merger was from 2012, so it's 9 years ago. And the court said, I understand it's difficult to unscramble the eggs, but I'm not going to consider that when I consider the plaintiff's delay in bringing the case. And this merger was also cleared by DOJ, and the court said the fact that the DOJ chose not to challenge it is irrelevant because there's all kinds of reasons why DOJ cannot bring a case, including resources.
Yeah. And just a plug for another episode of our OCA series. We have focused on this particular case in another episode. We'll put a link on that. And then I hope to shift gear a little bit and talk about another issue that in the one paper that you and Judge Ginsburg discussed, for which we will put another link on our website page, is that the use of evidence about the intent. So how is that problematic if evidence of intent is used as a proxy of probable harm?
Sure. So there's 30 years of case law in the U.S. that makes clear that intent alone, no matter how horrible, no matter how much you say, I want to kill the competitor, is not sufficient, that you need evidence of actual harm, that we're not punishing intent here. Now, I'm not saying that evidence that a company viewed another as a credible threat is never relevant. I think it can be combined with other evidence to show that the only plausible reason for the deal was to eliminate competition. So now we're getting into a little bit like the so-called killer acquisitions, which are a subset of acquisitions where there's no efficiencies. You're not buying them to combine engineers and R&D and products to accelerate development to the market, but rather you're buying them just to kill them. But this kind of case is going to be very rare, especially for those that were reportable to the agencies and survived what's called HSR scrutiny.
That's great. And I think your mention of killer acquisition is very, very timely. I think there are new phrases, new ways, or new analytical framework to discuss or look at things. What do you think, just relation to killer acquisition, what do you think in terms of analytical value that particular perspective is adding?
So I think it's really important to not label all acquisitions of potential or nascent competitors as killer, which some have done. The FTC and DOJ have a really nice paper, an OECD paper from 2019, I believe, in which they really clarify that this is a subset. This really means you bought them and you just killed them. You discontinued you had no intent of ever integrating and having the efficiencies. The problem is that how do you tell that? So there's a nice paper, there's one empirical paper called Killer Acquisitions by Cunningham et al. And it's in the pharma industry. And they study companies that discontinued a product, right? But they are very clear that the welfare effects of their study are mixed because we don't know whether discontinuing a product meant that you looked at it, and because a lot of deals fail. You get in there and you say, oh, wow, I bought a dud, right? So you don't know whether discontinuing means that that was their intent to always just buy it and kill it, or it just didn't work out. They also say the welfare effects were ambiguous because we don't know whether this kind of behavior, buying, startups or smaller firms, actually increases incentives to innovate in the first place, right? There's some literature that shows that a lot of startups are incentivized by being bought. That's what they want. And the other thing about the paper, because a lot of people rely on this paper as evidence of a killer acquisition problem, is that while it's a very important paper and we need empirical work, it is in the pharma industry, which is different, right? In pharma, we have measurable milestones, right? You have FDA approval. You have steps to let you know, are you heading toward a path of success? Are you likely to be a successful entrant? But in high tech, you don't have that, right? You have leapfrog, brand new innovations that come overnight. And so the paper is important, but it's likely not generalizable across industries outside of pharma. So it's really important that we do more case studies to study specific industries.
And I think this is where it's funny. This is where intent evidence may, as a practical matter, have a great deal of sway. Because if you see in the 4C documents, a company saying we're going to acquire these guys because they're our greatest threat, and as opposed to saying we're going to acquire them and grow this product or combine our products, that's where you might start seeing the killer acquisitions. The killer acquisition cases coming from. To your point earlier, intent evidence isn't necessarily evidence of effects, but it could very well motivate the regulators.
So I'm not as worried by documents that just say this is a big threat, unless they say we got to buy it and get rid of it. Because someone can think someone's a big threat, but there could be other documents that say, wow, we're really behind. It's going to take us 18 months to get there. This company is not only a threat, but they're awesome and they're going to get there fast. But let's buy them and let's integrate them with us vertically, or and give them our, distribution, or give them, and there could still be efficiencies. So unless they say, I want to kill it, I'm not as worried by thinking someone's a threat.
Okay, well, watch this space. I think particularly with the new administration coming in, I do think killer acquisitions are going to be a focus, and we're going to hear a lot more about them. So let's stay in touch, and we'll watch what's coming out. But let's shift gears a little bit. Can you give us some advice for young professionals that want to do what you do? Any suggestions?
Sure. I think I have three main ones. The first one is economics. Antitrust is all about economics. And so learn economics. I was really blessed. I did take some economics in undergrad, but I've worked for former FTC Commissioner Josh Wright. And then I went and taught. I got to teach Anora, which was a great gift, at George Mason, and learned economics from Josh Wright and Bruce Kobayashi. And it has been the saving grace of my career. I learned more economics from them in those years than my 17 years practicing.
Was there any math on the exam?
There was. They gave me hard papers. And yes, Kobayashi has a whiteboard in his office, and there's a lot of math.
What other advice do you have?
The second one is relationships. And so here, I'm a huge fan of the ABA. The ABA, I mean, most of my best friends I met at ABA events, and I've gone to Brazil with them or on family vacations. So it's very important to me on a personal level, but it also has been a wonderful opportunity to meet mentors and at some point in my career start to have mentees. And I, for like a decade didn't apply for a job because people really got to know my work in ABA because we do a lot of writing and people see how you work as a team member. It's a lot of consensus building. And people I got offered jobs sort of one after the other. I would say, wow, if you ever have an opening, I'd love to work for you. And then I would go work for them. It was wonderful. So I'm a huge fan of ABA and those relationships, which also feed into my third point, which is having some work-life balance. And, those friends are what's key for me, right? Having friends, especially in COVID, that you can go on COVID-safe walks with outdoors or do virtual game nights. And that work-life balance, I'm not always great at it. I think it's fun to write an article on Sunday afternoon, so I need some, help. But I found that, sometimes I can be really stuck on something. I'm writing a brief or something, and that intro just isn't coming together. And I take a break and I go do yoga or I go on a walk and I come back and all of a sudden the thing that was such a problem before is just clear, And so if you're a young attorney, I really suggest, as myself, a partner, I won't remember if an associate says, I'm sorry, I'd love to do that, but I can't right now because my plate is full. But I will remember if you take it on and then you can't do it because it's just too much. To really protect your work-life balance and have some boundaries.
All good advice. Well, tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
So after practicing law for about 4 years, I took a break to pursue a childhood dream of acting. So I really gave it a go. I moved to LA. I quit my job and I really pursued it for about 4 years. And it was great fun. In LA, there's a lot of really great film schools. So I got to be in a lot of really good quality short films for festivals and things. And then after about 4 years, I realized that I missed the law. I realized that I missed the writing and the analytical challenge. And so again, the ABA really saved me because I decided to come back to the law in 2008. When firms were laying off by the hundreds, and it was my ABA friends who really helped me get back in.
What was the greatest role that you had while you were a professional actress?
I was in this movie called Lost in the Wash, where I was the lead. So that was very fun. And it was actually a full feature, like hour and a half movie. And the director was just great. In acting, I found that it's hard to not be self-conscious. You have like 50, 100 people with mics and lights and telling you where to stand. And the director, just made me so comfortable. And it was a role where I had to kind of go deep and there were some emotional scenes and it was great to work on that.
Have you ever thought of combining your love of acting with your love of the law and do the Our Curious Amalgam movie?
Sure. Where do I do it? Where do I sign up?
We'll get in touch with your agent.
We also need the budget, John.
Let's go to our final segment, which we call The Curious Hat.
And now it's time for The Curious Hat.
when we are together, I have an actual hat, and in the actual hat, I have actual questions, and then we pull a question out of a hat, and we ask you the question that you pulled out. Since we are not together today, I have a list of questions in my right hand, and I will ask you, they're numbered 1 to 25. I will ask you to choose a number, and I will read the question that corresponds with this number.
17.
Okay, question 17. Okay, what was your favorite course in college?
Economics.
And why is that?
For me, it was a whole new way of thinking. And I just like the way that economists frame things. And I like that there's questions there's testable propositions, and you can actually go and test them, right?
So, what was your favorite class in college that was really, really easy?
Psychology. I don't want to say it was really easy, but it was very, I didn't feel like studying, right? Because you're looking at studies of somebody on the beach, and they ask someone to watch their bag, and people running after, that if you don't ask someone to watch your bag and someone steals it, people will let it go because they don't know, is that a friend? Or if you ask someone, they'll actually run down the beach to get the person. So it doesn't feel like studying, right?
I took rocks for jocks. Thank you for being on our Curious Amalgam, and we will see you next time.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.